Good morning, everyone. Happy Monday. Instagram, Facebook, YouTube. How's everyone doing? I have about 15 minutes today. Don't really have any topics today. I'm just here for frequently asked questions. So if you have any questions that you want to ask about immigration, today's the day to ask me that. Um, if this is your first time tuning in, my name is Aisha Chidole. I'm an immigration attorney. I represent clients all over the United States and internationally with their immigration matters. We handle U.S. citizenship, we handle green cards, we handle VAWA, which is self-petition. We handle marriage-based cases, fiancé visas, and the work. So if you guys have any questions for me that I'm able to answer, I'll be happy to answer them. I have about 15 minutes. If you guys want to schedule a consultation, the number is 407-995-6567. And you can also send a WhatsApp to 404-333-8751. Okay, let's see. Yeah, it's been a hectic one for me. I literally just flew back. I was out of town and flew back in last night. This month has been crazy between interviews and things that we're handling for our kids. So it's just been a crazy one. And I'm very exhausted today, but let's see what we can get in. Good morning, Ever Bless on Instagram. Good morning, Nancillus. Okay, Nadia on Facebook says, how long does VAWA take? Most VAWA cases take anywhere from 2 years to 2.5 years for a decision. Whatever anyone gives you a timeline, we're just giving you a timeline based on one, our experience, two, the published timelines that we see on USCIS, which lists what the processing time is. But it doesn't mean that you will necessarily fall in that category. You could very well get a decision 18 months, and you could very well get a decision 2.5 years later. So you can fall anywhere, but most people will fall within that 2 years to 2.5 years. Somebody asked on Facebook, how long after your approval can you put in for your I-485? Melissa on Facebook, can you confirm what approval are you talking about? What approval do you need that you're referring to about the 485? Sherry K, your question is the same as Nadia, so I just gave the answer to that one. Somebody on Instagram says, if you marry a permanent resident and you've overstayed, can you apply for adjustment of status, or do you have to wait for them to become a citizen? So because you're an overstay and you're married to a green card holder, you can apply for adjustment of status. The only time that you can be an overstay and apply for adjustment of status is if the person petitioning for you is an immediate family member, which would be, it's an immediate family relative that's a U.S. citizen. So either a U.S. citizen spouse, a U.S. citizen parent, and you as a child are under 21, or a U.S. citizen child over 21 filing for their parent. That's the only time an overstay is acceptable. Otherwise, you have to either wait for the person to be a citizen, or if your spouse is abusive and you qualify as a VAWA applicant, you can actually apply regardless of whether your spouse becomes a U.S. citizen or not. The third option is if your spouse can apply for the I-130 when the I-130 is approved, you can do what we call a hardship waiver. If a hardship waiver is approved, then you can go back to your home country, do your interview, hopefully get approved, and then come back here as a green card holder. Okay. Let's see. Good morning, Lioness Queen. Good morning, Polo Low. Sean is asking about, I've been waiting to get an asylum interview for almost 5 years. I don't handle asylum cases, so I don't want to talk about it. Let's see, what else do we have here? Good morning, Krishna from Poughkeepsie, New York. Good morning, K Faith. Good morning, Alex Johnson. He says, on what grounds can someone who's lived in the U.S. for 5 years undocumented with a clear history and moral value obtain work permit? Sadly, none. It doesn't matter how long you've lived in this country. As long as you're not documented, you can't just get a work permit just because you've been a good person and you've not gotten into any trouble. Now, if you qualify for TPS because you're part of one of the countries listed for TPS, i.e. like Haiti or Venezuela, then you can get a work permit on that ground. But just being undocumented alone is not enough. Or, if you qualify for DACA, that's also another grant. But again, how long you're here is not enough for you to now become eligible for a green card. Okay. So Mon P says, I have an infant with my ex-girlfriend. She is in a foreign country. What are the processes of getting the child a U.S. citizenship? He's under 3 years old. So if you're a U.S. citizen, your child can derive citizenship for you. So you can certainly get citizenship. Usually if the child is in the other country, you do it through the consulate of whatever country that person is in. Lioness, for a consultation, it's $150. You can call us 407-995-6567 or WhatsApp 404-333-8751. Sandy says, I sent in my paperwork 3 months ago and I haven't received a receipt notice as of yet. Do you think something is wrong? Could be. 3 months is a long time to not have received a receipt. So you might either be getting a rejection packet back in the mail. Like if there was something wrong with it, they'll send you back the entire packet together, saying the reason why they're rejecting this application, or make sure you send it to the right address. One of the things I always say for those of you who want to try and do this yourself, you want to make sure that you are tracking your mail to make sure that the stuff was actually received. I don't advise you to do it yourself, but if you do, you want to make sure you're tracking your stuff. Okay. Somebody asked, please, when can someone file for naturalization when you get an extension letter and a 10-year green card has not been issued? You can file if you're currently still married to your spouse and you've had your green card for 3 years. Right? So you and your spouse have been married for 3 years and you had your green card for 3 years. Then you can file for naturalization, even though you're waiting for your permanent green card. This is for those who are conditional green card holders already. Or the other option is if you know for a fact that you're going to be approved based on abuse, that also allows you 3 years. Otherwise, the timeline is 5 years for everybody else. Okay. Nansila says, good morning. I got denied and I'm applying for the second time. I submitted it since last year, September. I don't know what you're referring to. What did you get denied from? What did they deny you for? Okay, let's see. Okay, so Sherry K says, will your underage child on your VAWA application get advanced parole as well? This is actually a good question and something that confuses people a lot. So let's go over it. If you apply for VAWA and you have any child under 21 in the United States, you can apply for adjustment of status and work permit and advanced parole with a child as you would file for yours as well. If you do that, the child will get advanced parole approved if you get advanced parole approved. That's number one. If the underage child is outside of the United States, you cannot apply for anything for the child at all. The only thing is that the child will be listed in your own I-360 as a derivative beneficiary. And what that means is that if you get approved for VAWA, your child can use that I-360 approval as the basis for consular processing and getting a green card to come into the United States. So you get the difference. If the child is here, then it's easy to file for adjustment of status. If the child is not here, you have to wait till your process is over. Then you can then apply for the child. Okay. Good morning, Justina from LA. It's super early there. Okay, let me see. All right, guys, I have like 6 minutes left. Let me just see what other questions here. Okay, so someone says, hey, Queen, good morning. What's the procedure to file for a child over 25, overstay? I'm a resident. The procedure is you can only file for an I-130, and then the person has to go back. You can't as an overstay do an adjustment of status. you have to do a 601 waiver. You have to, and the waiver has to be approved. Sorry, not 601, 601A, but it has to be approved. Like the hardship waiver has to be approved. Otherwise, once you've passed 21, it's really nightmarish being an overstay here trying to get a green card through your parent. Oh, this is so nice. This says, guys, she's a very good lawyer. She's our lawyer. She's so supportive, understanding. I love the Chidori Law Firm. The staff is amazing. Love from the cases. Thank you so much. I really appreciate it. Ogana Jerome says, good morning, ma'am. I sent an email since January 21 at 1:15 p.m., but still have not received any feedback. I was hoping to get feedback today. It doesn't appear that you're a client of ours, so if you want to talk to us, you should schedule a consultation, 407-995-6567. We get lots of emails and things going to spam, but if you're a client, you know that you can use your client portal, but it does not appear that you are one of my clients. Okay, let's see what else do we have here. Okay, so this is also a good question. If you have a child that's a U.S. citizen, at what age of the child can the parent apply to get citizenship through the child? So a parent cannot get citizenship through a child, but they can get a green card through the child. And then once they've had the green card, 5 years later, they can apply for citizenship. So the child has to be 21 and able to sponsor the parent. Or if they are not able to sponsor the parent, then you have to have a joint sponsor that will sponsor. Okay. Davis says, good morning from Georgia. Good morning. I actually just got back from Georgia last night. Let's see, what else do we have? At what point do you get a prima facie? Is it before biometrics? If it doesn't come, is this a problem? So prima facie, really, it's really hard to say when you're going to get it or when you're not going to get it. It could be before biometrics. It could be after biometrics. Yes. For those of you who don't know what a prima facie determination letter is, that's a letter that you're given when you submit a VAWA petition, meaning that your case is approvable. As I always like to say, it is not a guarantee that they're going to approve your case. It's just saying that you've submitted the bare minimum. And so now we're going to use a fine-tooth comb to go over the rest of your stuff. And that's where they will list all your children that are derivative beneficiaries. If you don't get a prima facie, it is a problem because that means you're saying that your case is not approvable thus far. That being said, it depends on how long ago you filed your application. Some people file their application and you might not get a prima facie till like 9 months later. 9 months later is a long time, but it does happen. Sometimes they'll actually issue it and just forget to mail it. We saw a lot of that in December, like for people that were issued in June and they didn't get it till like December. So, it just really depends on how long your case has been pending. It's Cosmolot. I answered your question in the beginning. So if I'm going to save this and then you can just watch the beginning to see the question. Rich Booty says, do you think it's better to submit all the forms at once, or is it better to wait on a response from USCIS? Your question is very generic. I don't know what forms you're talking about. But if you're eligible for something, submit it all at the same time. If it's eligible to be submitted at the same time, there's no point of waiting. You can do concurrent filing if you're eligible for something. Let me give you an example. If you're submitting a VAWA petition and you're also eligible for adjustment of status, submit the VAWA petition and the adjustment of status and the work permit and the travel permit applications all at the same time. Khalil Joe, thank you so much. I really appreciate it. It says she's my own lawyer too, very intelligent, very dedicated, and someone you can trust to have your total breakthrough from immigration stress. I really appreciate you guys this morning. Thank you so much. Okay, this is the last question. I got to jump off. I have a meeting. If American citizen is divorced before the interview, what is your chance to survive? Well, this question is very generic. What interview? Is this a marriage-based interview? If it's a marriage-based interview, your chance to survive is 0. If it's a conditional green card, you have a very strong chance of surviving as long as you can show that your marriage was in fact legitimate It's just that you guys didn't work out and now you're divorced. All right, guys, I hope you guys have a wonderful day. I think this is the first week that I don't have like 3 interviews. Guys, this January has been crazy. Interviews every day. But so far, we're getting so much good news for our clients. In fact, I got more good news on Friday. I'll talk about that later. All right, guys, I will talk to you guys later. If you want to catch me live, I usually come on sometime between 9 a.m. and 10 a.m. So hit the subscribe button, notification button on Facebook, Instagram, and I'll be happy to help you. And guys, help me get to 10,000 followers on Facebook. Please share this video if you found it helpful so other people can follow me, or invite your friends to like my page. All right, guys, bye.